Good morning, everybody, and welcome to the Appropriations Committee for Corrections and Judiciary. We know that you are excited to be here, and we're excited to be here too. We're going to call the meeting to order and welcome members, everybody that's in attendance as well. I'd ask the clerk to take roll, please, for today's.
Chair Slaw.
Here.
Representatives Markkinen.
Here.
Beeson. Cavett.
Here.
O'Neill.
Present.
There are 4 members present, Mr. Quorum, or Mr. Chair, you have a quorum.
All right, thank you. And Representative Cavett then moves to approve the minutes from our last subcommittee meeting of March 27, and there being no objections, the minutes are approved. And now we get a chance to call on Marlena David, Deputy Director and Acting Director of the Michigan State Appellate Defender's Office. That's a title. Anyway, so I look forward to your presentation, and I will turn it over to you.
Thank you for having me today. Good morning, Representative Slaw, Majority Vice Chair Markkinen, and Minority Vice Chair O'Neill, and esteemed committee members. Thank you for having us here. I'm here at the table with Tina Olson, who is the managing attorney of our juvenile lifer unit, which is a topic I know we will explore today. In the audience with me from the State Appellate Defender Office, to my right is managing attorney Jessica Zimbelman of our direct appeals unit, Kathy Swedlow, manager of our Criminal Defense Resource Center, Brian Vance, our finance manager. So thank you for having us. I think I missed anyone. Representative Slaw, as you said, I have many titles at SATO. I'm the deputy director, but acting director as well, and I also serve as our training director and project reentry manager. I've been with SATO for 18 years, an attorney for 16 years, and in leadership for the past 10 years at our office. I was part of the original team of representing the 17-year-olds when all of this came out, so I have some good institutional history that hopefully I can share with you all on how those cases progressed. I do want to obviously address the main topic today, the impact of Sarnecki and Taylor and what that looks like for our state, and also SATO's remaining fiscal year budget needs for the operation of the rest of the work that we do at SATO. So we do have a juvenile lifer unit at the State Appellate Defender Office, which Ms. Olson is a manager of, and the unit was formed after the United States Supreme Court decided Miller and Montgomery. Miller was 2012, Montgomery was 2016, and in that case, the United States Supreme Court said that mandatory life without parole for people 17 and under was unconstitutional. They said that that penalty is still available. It's just that you have to go through some more fact-finding before such a sentence can be imposed. So at that time, Michigan had the second largest number of juvenile lifers in our state in the country. So we had 363 individuals who were entitled to resentencing at that time. And the State Appellate Defender Office stepped up and said, we want to do this representation. These folks are entitled to representation for these resentencing hearings, and we think as an established state agency with qualified attorneys, we are in the best position to do this so that these people can get resentenced and we can have some finality of the sentencing decisions. So SATO ended up representing about 193 people at that time. We had a staff of 11, and we were borrowing from a few staff members from our direct appeals team who were supplying representation at that time. I wanted to clarify, too, that when we have these resentencing hearings, the real issue that's being reviewed is the sentence. So we're looking at the sentence. It's the very rare case that the conviction is actually coming up in some collateral type of review here. It happens, but it's very rare. In most cases, we're just looking at what sentence now should this person receive. Should they receive a life without parole sentence again, or should they receive a term of years sentence? And that term of years can be anywhere from 25 to 40 on the minimum and 60 on the maximum. So with the 17 and under group, I wanted to talk about what the process was back then in 2016, because the same process applies today for what we have going forward. And the benefit is we now know 9 years later what worked, what didn't work, how to be more efficient in the representation and things like that. I wanted to address the 180-day timeline too that prosecutors are now under to file motions, and wanted to clarify what that means. And again, this is the same thing that happened in 2016. So the statute 76925A does indicate that prosecutors have 180 days from the date a decision is final to file for life without parole again against the individuals they want to seek life without parole against. So there are some individuals in certain counties, prosecutors have decided we're okay with the term of years here, we're not going to file, so they aren't within that 180-day timeline. But the 180-day timeline, to be clear, is to file a motion of whether you want to seek life without parole or not. No resentencing hearings or Miller hearings have to take place in that time frame. The time frame for actually going to the resentencing or the Miller hearing, that's coordinated by the prosecutor, defense attorney, the circuit court, and everybody agrees on a timeline that makes sense for the work that needs to be done so that it's done properly. I also want to note that the 180 days really is, it turns into 9 months rather than 6 months, because the way the statute is written, it's from the date the decision is final, and it's not final until the time runs for the prosecutors to be able to appeal if they do want to appeal to the United States Supreme Court. In this case, and I'll talk about Sarnecki-Taylor in a second, we don't expect them to do that because that case was decided under Michigan's Constitution, but if that timeline still applies. And so we have been in communication. I have a meeting with Pam on Monday about the timeline and budget and other things like that. But our understanding now, as of a few days ago, is prosecutors are on the same page in that for Sarnecki and Taylor, which I'm going to get to in a second, their 180 days plus the 90 days actually gives them until January 5th of 2026 before they have to file motions whether they want to seek life without parole or not. So there is some time here for prosecutors to decide whether they want to file. And I'm going to go back to the 2016 process really quickly. In 2016, what happened during that time frame that prosecutors got to decide is that prosecutors ended up filing motions in almost all cases, not all, but a large percentage, 67% of cases, and then they withdrew them later. A lot of them were withdrawn later after prosecutors decided, oh, I now know information about this person I didn't know, and we're not seeking life anymore. So prosecutors in this process have very wide discretion whether they want to seek life without parole in the first place, and there's all sorts of ways they can preserve that right by filing a motion and then later withdrawing it if they learn more information about why they don't want to seek life without parole. I also want to highlight that the real time crunch does come for the defense, who then has to answer these motions when they're filed within 14 days. And so that's part of the statute and the timeline that we're running on as well. And we, of course, don't have any control when the prosecutors decide to file. We don't know when they're going to file, if they are. And so our team from the get-go is researching and working up these cases so that we know how to respond in that very quick 14-day time frame when that happens. And again, there's no statutory timeline for when the actual hearings have to happen. The big bulk of the work is these Miller hearings when the prosecutors are seeking life without parole. That is where all the work comes in, and maybe sometimes week-long hearings, but that can be scheduled for later dates. And many people may not even be ready to go to those hearings without a year of prep in between, okay? So the timeline is quite expanded there. Like I mentioned before, in 2016, when we were representing the 17 and under, we still are representing the 17 and under too, is another point I want to clarify. At least in our office, we still have about 9 people from the 17 and under group that still need to be resentenced, still need to go to Miller hearing. And some of those cases have come back on appeal. I'll talk about appeals later too, because that's a really big issue for this committee too, I'm sure. And so 11 staffers have been doing this work for the past 7 years for the 17 and under. And for that group of people, SATO represented about 193, as I mentioned. We went to 43 contested Miller hearings. Those are hearings where the prosecutor is seeking life without parole. 9 of those resulted in life without parole, and 6 of those have been reversed on appeal. So out of the 43 contested Miller hearings, only 3 ended up ending in a life without parole sentence, and this is because the trial court, after hearing all of the evidence that was presented, determined that under the law, the only appropriate sentence was a term of years sentence. Now, in Parks and Pool, which are two other cases that were litigated in our Supreme Court, it was then all of this whole process was then expanded to 18-year-olds. So the cases, Parks came out in 2022, Pool originally came out in 2024, but it was just declared retroactive on April 1st of 2025. So that retroactivity just was established. And so the 180-day plus 90-day timeline for that case, for this group of people, runs on December 29th. So on December 29th is when the prosecutors for the Pool group have to decide if they're seeking life without parole or not. So there were 275 people in Michigan that were entitled to resentencing under this group. SATO represents 168 of those individuals. And when Pool came out, the state did grant funding for an additional 7.5 staff members for our juvenile lifer unit. So right now, as it stands, our juvenile lifer unit has 18.5 staffers representing 168 individuals under Pool, still some people under Miller and Montgomery. And then I don't want to get into the weeds, but we also have a case called Stovall for parolable life sentences that's also impacting the caseload of our juvenile lifer unit. Happy to provide more details, but I wanted to just kind of highlight there's a lot going on for the juvenile lifer unit as it stands. Again, same exact process, and the time is currently running. I just mentioned that the time is running for that group, and the prosecutors have until December 29th, and then we have 14 days to file our answers in those cases. And then we get to Sarnecki-Taylor with the 19 and 20-year-old group here. There are about 582 people in Michigan. SATO, given the fact that we have, for the past 9 years, established a highly effective juvenile lifer unit with all of the expertise and knowledge needed to make sure that these cases are done right, we want to be able to represent as many people as possible and to take the burden off of the trial bar who would probably have to halt some of their normal work if they were required to represent this group of people. And so we're estimating about 300 people our juvenile lifer unit could represent if properly funded. And I want to go back to this idea of SATO being the best place to do this representation in that we know firsthand, Tina and I, Jessica, I think Kathy as well, all the lawyers in this room on staff and in management have represented people at these Miller hearings and have done this litigation. And we agree that the impact on victims' families is incredibly difficult. It is very difficult to come back for hearings where people are now going back and having a chance at freedom and their loved ones don't have that freedom. We are very aware of that. Our staff is trained to be aware of victims' needs and harm in our hearings, and we approach that with great care. The reason this work is so important for us to do is because we want to do it correctly so that victims' families do not have to come back on appeal. We have had so many appeals from the original 17 and under group where the appellate court said, this wasn't done correctly. This Miller hearing wasn't done correctly. You denied the defense of this expert, or the defense attorney failed to do this work that they were required to do, and now guess what? We have to do it all over again. We've had some cases that have resulted in multiple Miller hearings and some cases that have resulted in different evidentiary hearings and hearings leading up to it too. We are trying to minimize that impact to victims' families by doing it right correctly, and all of our staff knows how to do it right correctly. And I think that bears out by the numbers of results from the life without parole cases for the original 17 and under group. I also wanted to highlight very quickly the work of Project Reentry and how that impacts the work of the juvenile lifer unit. This committee is aware that reentry is a public safety issue and that it is in all of our best interests that when we bring people home from incarceration, they are prepared to stay home and they are successful and they do not recidivate. Part of our funding request has funding for reentry. Our reentry project was launched in 2016 with absolutely no funds. It was volunteer-based, and now it became very quickly in 2016 something that prosecutors and judges demanded. When we spoke to prosecutors and judges about how we were going to move forward on these cases, one of the first questions was, what's the reentry plan? Where are they going to live? Do they have any support? Because that is what is on everybody's mind when you send a 19-year-old, 18, 17-year-old to prison and they come home at age 60. The world is very different, and a lot of hand-holding has to take place, and a lot of guidance and resources. And so our Project Reentry launched seeing that need. And I understand Corrections does reentry work as well. Our reentry work is a little bit different in that we help in the litigation phase of it, providing prosecutors with the plan in advance, so prosecutors can say, does this look compelling enough that I'm okay with this person maybe one day being paroled, right? Or is this plan pretty, there's nowhere for this person to go, or they don't have resources and you need to work harder to figure out where this person's going to go. And that's what our reentry team does. These are just a number of clients, and I don't mean to be insulting, but these are old men that you see on this screen, old men that are coming home after they were incarcerated at age 18, 17, 16, 15 years old. And they're elderly, they have health issues, they have, for some of them who are lucky, they do come home to families that are supportive, and the large majority of them are doing well. If this committee wants recidivism information on the juvenile lifer population, you may already be knowledgeable of it, but it is extremely low, not only in Michigan, but nationwide, and that is because what the United States Supreme Court relied on in granting these resentencings is the idea that people who go in at young ages or commit crime at young ages, they have a greater potential for rehabilitation than, say, your 40-year-old who's out there committing crimes. And that's what was recognized by the court, and that is what we see bear out in this 9 years that we've been doing these resentencings, is people are coming home and staying home at a way higher number than your average prisoner population. And I think even if you speak to corrections staff, it is often the juvenile lifers who inside who are the best prisoners, who are the ones who are raising the bar for how behavior should look in the prison system. And so our reentry team addresses this on all sorts of levels, not only for reentry planning when we present cases to prosecutors and prosecutors and judges, but also on the back end. Now, we don't have funding to provide. I want to be clear, our reentry funding is not to provide these resources directly. That is not what our reentry team does, but we can point out resources, refer people to different sources, make sure people understand this is what it means when your parole board or parole agent says you have to be at this place at this time, and this is the bus that will help you get there, right? Or other ways that we can help. And so that's what our reentry team is doing, and they've been doing it incredibly successfully for the past 9 years. I also wanted to highlight that not only does our reentry team do work for our clients, we also do work for everybody else in Michigan's community. We have free resources on our website. This reentry book is available to anybody that wants it. We also host monthly workshops at our office. It's tax week this week, and we just hosted last month a tax workshop in our office to help people understand what they need to do. Now, what's interesting about these workshops, they are completely voluntary. People that come are not told to come there by their parole agent, and many of them are not even on parole, but we see them populated very heavily by Michigan's juvenile lifer community because they want to stay home and they want to be productive members of the community, and they are doing the work to do that. So there are obviously with the new case decisions, Sarnecki and Taylor, of course, there are financial implications and budgetary needs related to that. Our juvenile lifer unit, before I get into the ask, is I wanted to highlight these numbers, and I understand that in putting up these numbers and saying to you all that since 2016, we have saved over $94 million in corrections cost. It's not, in this Appropriations Committee knows better than me how the appropriations in the state work. It's not as if you see a refund, right, at the end of the day. It's not as if the pocketbook grows. It's just the fact that the money allocated to house these individuals for life is no longer needed for their bed space when they get out at maybe, let's say, age 60, when we were actually planning for them to be in for the remainder of their lives. And so that's what this means. This committee is in a unique position that you do oversee corrections budget and judiciary budget, and perhaps there are different creative ways of saying, if it's not for bed space, what can it be used for that it could be effective, like reentry. Many of the committee members may also know that when you are sentenced to life without parole, you do not have the ability to access programming in the Department of Corrections because programming is prioritized by out date, and you don't have an out date when you have a life without parole sentence. And so, no fault to corrections, but they simply don't have the resources to give everybody the programming that they need. And so this is, we've been doing it for 9 years. What can we do with the savings that we are seeing bringing folks home that is more effective to advance public safety and to help people who are inside get programming before, sometimes it's 30 years before they can access programming. And this is not just for juvenile lifers. If your minimum term is 30 years, you got to wait a long time before you get into programming. And there are exceptions to that, of course, and nuances, and sometimes you can get in if you're persistent enough or if your facility happens to have resources, but that is an issue. And the question is, what can we do with the money that's being saved in corrections costs? And I think this committee is in a unique position to think about that. So the budget request we have related to Sarnecki and Taylor is, I think, a very responsible and efficient budget request. It is for 14.5 positions at $2.3 million. And this would allow us to add enough staff to represent about 300 people that are in need of constitutional representation for these hearings. It also, 2 of these positions include mitigation specialists for the Michigan Appellate Assigned Counsel System. Our Michigan Appellate Assigned Counsel System roster is experiencing a backlog, a very hard time getting counsel for people who are on direct appeal. And so adding the Sarnecki and Taylor group to the max roster attorneys is going to be burdensome, but we have estimated that they will be able to represent a portion of these individuals as well. And so they also need resources. They are under our office's umbrella, the Appellate Assigned Counsel System. So this includes enough attorneys, mitigation specialists, reentry, paralegal, and support so that our staff, our juvenile lifer unit, can provide representation, not only representation, very good representation so that we don't have to do this again on appeal and keep this process going. I know the focus of the hearing was this impact, and I know there will be questions afterward, but I wanted just to finish with our other budget priorities. So, as of last week, this Sarnecki-Taylor budget wasn't our budget priority. We had other budget priorities that we wanted to present to this committee and that we still need for the work that we're doing in the other units of our office. One is another $2.3 million for 12 full-time employees in our direct appeals unit, and this is for implementation of SATO workload standards. The National Center for State Courts reviewed our attorney caseloads and determined that our appellate attorneys' caseloads were almost 2 times higher than they should be given the complexity of appeals in Michigan. We instituted a 3-year phased-in plan for getting our caseloads under control. And this is year 2 of that plan. We were funded last year in year 1. This would be year 2 to add 12 additional employees to our staff for that representation. I'm going to back up one more time because I forgot to mention related to this budget as well. As you'll also see, this is also a multi-year plan. We did not come here asking for 30 employees all at once, which is frankly what we think we would need to get these people represented and resentenced within a reasonable period of time. We want to be responsible with our request, and so we are doing a phased-in request where this is just year one. Let's see how much progress we can make, because a lot of it does depend on what prosecutors do, and we don't know yet what prosecutors are going to do, so that's why we did a phased-in request, and that was year one. Again, for the direct appeals unit, we are on year 2 of our phased-in plan to decrease workloads, while at the same time allowing our office to to represent a greater portion of people, so that we are relieving tension on the max roster that just simply does not have enough attorneys to represent people. We also are asking for a nominal fund to pay our interns. SATO is an outlier in failing to pay our interns, and because we do have, like I said, a shortage of roster attorneys, I wanted to highlight, and maybe this committee does know this, there is a shortage of lawyers for prosecutors and defense attorneys, period. There is a shortage, and it is a problem. And one of the ways we're trying to address that is creating interest at earlier levels. And one way we could do that is to pay people who are interested in public service, because people these days cannot afford to just intern for free. Everything costs something, and we really would like to be among the prosecutors who do pay their interns, courts, legislatures, and so we do want to be able to offer funding so that we can grow public defenders and have qualified people, and the system works best when everybody is competent and well-equipped. We also are asking for, as a current service baseline, we are asking that our contract through our collective bargaining agreement is implemented to raise salaries to be in parity with the Attorney General's office and also with trial level defenders. We cannot continue to compete and have excellent staff if we are not increasing salaries and paying our staff at rates that are reasonable. So those are our budget requests. And I have my contact information here, and I'm happy to answer any questions the committee has about those requests.
I'm up first. Well, first of all, Madam Director, I really want to thank you for just your presentation. I'm sure for me, you've answered a lot of questions that were just obvious questions, and I hope it did the same for my colleagues. In terms of just the facts around this decision, there's a lot of misinformation going out, and I think you've sort of eliminated a lot of that because you told the facts. The public safety issue was one of the main concerns for folks, and I've just seen some of the threads being going out and stuff, and that's not the case. And you respectfully said, these are old men, coming out, after spending so many years in institution, and then the process that you use in terms of, your expertise with your team. I want to give you credit and your team credit for being methodic and being matter of fact, because to revisit the issue with re-victimizing the victims, that was another concern for all of us. Your case presentation illustrated the care and the consideration you have for the victims by mitigating reoccurrence of coming back. That's important. So thank you for that. Also, I like the fact that you're methodically phasing in process in terms of how you go about doing your work, and making sure that the cases are handled properly, making sure your workload is properly allocated based on your staff levels. And the intern part, I think, it adds to the value of building that pipeline, if you will, supporting this whole industry. In all sectors of the economy, you have shortages. And so you're addressing that. I like the reentry plan aspect as well, and that's something we do in corrections. And the Offender Success Program has done some outstanding work with collaborative from all of us, making sure that those facilities that we can have those programs in, they're in it. And we had a great report a couple meetings ago about the impacts of that. So I can appreciate what you're saying and how important it is. And so the public safety concern for me is really strongly considered and eliminated because of the work you're doing. I think we cannot echo that enough. And so I appreciate that. And I just want to, again, thank your team for the work and care and consideration for the victims, because, the trauma, that's another big issue that people bring up all the time to try to politicize it, and that's not what we're trying to do. This is a serious, serious, life-altering situation for everybody. And then the money we spend for corrections, and then supporting, the court system is serious resources. And you're showing us the return on our investment. I mean, how can you argue that? Was it $94 million, I think it was? Yes. 94? I mean, come on. And then how can we help? I like the fact that you said, how can we help corrections, redirect that money toward other viable amenities to support those who are coming out? So, Mr. Chair, thank you for your obliging the time, but I think you've eliminated a lot of speculation, hopefully, by giving the facts as you have, and your concern and consideration for the public safety side as well as the victims. So thank you.
Thank you, Representative.
Thank you, Mr. Chair.
Let me ask just a clarifying kind of question. So when you talk about these are older folks that were coming out, my understanding is that they would be all 19 or 20 years old at the point of the crime, and then it would be a 25-year minimum sentence before they would be actually available to come out. Is that under this?
That is correct.
So 45 would be the minimum age, roughly, and they would be older from that age up. Is that?
That is correct. And a large group of these, so yes, some could be younger if they get the bottom term, right? If they get the lowest possible number of years, they could be younger coming out if the parole board decides they're ready. But in this group, and I can get you numbers so that I'm not off the cuff, but in this group, I want to say there are roughly 363-ish who have served. Is it the minimum or over 40? I'm going to get you the numbers, but this group is larger in the 40 and over camp. Like they've already served 40 plus years, and I can get you those exact numbers of the breakdown of ages. But you are correct. It's possible that some folks could get paroled in their 40s if the parole board determines that they're eligible for parole. But they could also be held up to 60 years or whatever the maximum term is if the parole board does not believe that they are safe.
Rep. Markkinen.
Thank you, Mr. Chair. Thank you for your presentation. It's very informative. Under Charneski and Taylor, you mentioned 582 in Michigan, and it's estimated around roughly 300 represented by SATO. Who typically would represent the rest?
Yeah, so we have, as I mentioned, the max roster attorneys will represent a tiny chunk, maybe around 20, but the trial bar will,
Trial bar?
Yeah, the trial bar, and we have been in talks with the Indigent Defense Commission about that, and they are aware, and we've given them county breakdowns of what that could look like for certain county defenders. So my understanding is they understand they are going to have to represent a certain group. We also, in the past, in the 17 and under group, there were some pro bono people who stepped forward, law firms that would take, a person here or there, but that's sort of dwindled down over the years, and so I don't know if that resource will be available anymore.
Thank you.
Yes.
Representative O'Neill, you had a follow-up question?
Yes, just quickly. On this decision, I just want to be clear. This is not a get-out-of-jail-free card,
Oh, no.
correct?
No, it is not. The convictions are staying in place. The question is, should this person, after considering all of the factors, be resentenced to life without parole, which is an option, or should this person get a term of years where we let the experts in the parole board determine whether that person should ever come home or not? And so, no, I wouldn't say a 25-year term up to 60 years is get out of jail free. That's a long period of time. And so they're serving very lengthy sentences. And again, it is up to the parole board to say whether they're experts in determining whether somebody is a public safety risk or not. And so, no, it is not a get out of jail free card.
Thank you. Thank you, Mr. Chair.
Absolutely. So my next question is, and you'll just have to excuse me because maybe I didn't really understand it. But what I thought I heard you mention in your presentation was that there's it's kind of a joint request between SATO and the prosecuting attorney. So I need to make sure I'm understanding what that is and
Yeah.
how we're going to see that.
Yes, let me clarify that, Representative Slaw. I'm sorry for the confusion there. Back in 2016, we did work with Pam to submit a joint budget request for that group of people. We've not had Pam and I have not had the opportunity to meet yet. We're meeting on Monday to talk about timeline, budget, other things like that. My understanding is both would be supportive of the budget asks that the other is asking for. There's no doubt prosecutors also need to be funded to do this work and to do it properly and quickly and timely. And so we have not yet agreed on anything other than we want to work together, we want to talk about it, we recognize it happened in 2016, and we are willing to talk about it and what it looks like this time around. We just haven't had the opportunity to meet yet.
Great deal. Thank you for being here. We appreciate the information. And as Representative O'Neill said, it's nice to have the real information, maybe rather than the speculative information that you hear in the community.
Yes.
So thank you for doing that. Thanks for being willing to put it together and be in to talk to us.
Thank you, and I am willing to talk to anybody else in separate meetings, so please reach out if you want any information. We have wonderful people on our staff. One person who's not here, Chelsea Richardson, our mitigation supervisor, who is our data person, and constant request to her of information. So if you do want more information about this population or our past work, please reach out. I'm happy to speak with you all individually as well.
Great deal. Thank you very much.
Thank you.
And with that, seeing no further business, this meeting is adjourned.